Sir, shall we begin? I think more people will join in due course. So we're already running past time.
I'm okay. We can start, and your asset is taking a recording, so if anyone wants to listen, can listen it later also.
Yeah, recording, it's automatically recording is there. So,
Okay.
right. I'll actually start, sir, by introducing myself and the university, and I'll give a brief introduction about the resource person for the day. So I welcome all the participants for joining this today's webinar organized by Gujarat Maritime University. So a brief introduction about the university. So actually, the Gujarat Maritime University, it has been established under the blanket of the Gujarat Maritime Board. So that is the sponsoring body, that is the owning body for the Gujarat Maritime University. So it's basically funded by the government of Gujarat. So it actually aspires to be a global center of excellence in maritime education, research, and development. And it aspires to bring out professional training, and it aims to increase and enhance the human capital and the capacity of maritime industry, both in India and across the globe. Now, the aspiration is to serve the global maritime community by producing educated and well-trained professionals in the maritime domain. Now, at present, the university offers programs which are catering to the commercial aspect of maritime, such as MBA program for shipping and logistic, the LLM program for maritime law, and the LLM program for international trade law. Now, the university from time to time also conducts short-term executive development programs and management development programs specifically targeted to train the already working people, already industry working with those kind of people who are already working in the industry. So it tries to provide trainers for training for trainers also, kind of an initiative. So this is a brief introduction about the university. So I myself is an assistant professor at Gujarat Maritime University. Now I'll just give a brief introduction about the resource person for the day. So Mr. Muthu Jagannath, he is an Asian-based claim consultant, arbitrator, mediator, specializing in shipping, international trade, and marine insurance matters. Mr. Jagan has over 25 years of working experience in shipping, international trade, and marine insurance. He has been involved in arbitration both as party appointed representative and as an arbitrator in the London Maritime Arbitration Association, the SEMA, the SIAC. Now, Mr. Jagan has also started he had started his career with a shipping agency in India itself, and then relocated to Singapore in a similar role. And now his interest in claim led to a similar kind of a role in a P&I corporation company at Singapore, dealing with basically various type of P&I and FD&D and transport liability claims. Now, he subsequently moved to a commercial role in a liner shipping company, headquartered in Singapore itself. And he founded the NAU PTE Limited, a claimant correspondent and consultants in 2013, and assisting clients in various type of shipping related claims. Now, thank you so much, sir, for agreeing, for accepting our invitation and for giving this particular session on this very essential topic. Thank you for joining us. So,
Thank you for the kind words. Please. It's just that
I,
if I tell my wife that you're speaking so glowingly, she'll probably be very happy to hear. But unfortunately, she is not here. Please continue.
Yeah, so sir, I'll just give a small address to the participants. So sir, as he is very much open to any kind of questioning. So in case any of you wants to communicate, wants to ask any question in the middle of the session, so wants it to be a deliberation rather than one person speaking altogether. So at any point of time, you can write a message on the chat box. If you want to speak, you can request, you can write on the chat box to unmute you. I will be very happy to unmute you and to entertain your question. So this is all. So I think I can hand it over to you. We can begin with the session.
Thank you very much, Abhay. I think the precursor for this webinar was, I guess, the text article which I wrote for what do you say, the shipping and freight resource, which somehow landed up to your colleague's desk, and you all asked me. Before that, there was a gentleman who had actually, said that he's going to put my name to universities in India because he's involved as an adjunct. So when you approached me, I thought it was from his reference, not realizing that I've bitten more than I can chew. Actually, I had a seminar or a talk again on Friday. Today is Monday, so there's a second seminar in 2 days. So I'm happy to share my thoughts. This is more of a conversation than of a one to, only saying that this is the right way. And when you ask me to speak on the liabilities of a shipper in a bill of lading, I thought it is better that I look at some new topic in which I also share my thoughts. So let me share my presentation. Just give me a second so that I can try and work that out. I guess you all can see my screen.
Yes, sir, it's visible. You can see your screen. People.
Okay, I am going to actually be speaking about the role of a P&I and a claims correspondent. While you talked about my company, yes, I started now in 2013. I basically acts as a claims correspondent to anyone who can engage us, of obviously a remuneration as long as there are no conflicts, and as long as it's related to shipping or related matters. We don't focus only on one geographical location. Claims, I have handled claims all the way right from South America to China. But yes, we would need to use local resources, local correspondents to deal with it. So I will probably explain, what a P&I correspondent does, what a claims correspondent does, and we'll take it from there. So at the outset, what am I going to speak is basically what is P&I, what are the other types of claim which you will probably see in this industry. There are two types of correspondents, the commercial correspondent and the legal correspondent. Having said that, when I started my career first in shipping, I actually started in Cochin. You would generally find only a correspondent. You would not have that distinction. But yes, sometimes in the rule books, you find a distinction between a commercial correspondent and a legal correspondent. I'll touch on that. Then I will touch on my thoughts and on my journey to being a correspondent, and what is necessary if any of you decide to get into this career at a later stage. One of the reasons why I thought is, Gujarat Maritime University is actually trying to build people with maritime knowledge. And this might be an opportunity for people to look at this, they look at career options, where they can look at. If you look at P&I stands for protection and indemnity. Any ship which wants to trade would need to have liability insurance. By way of background, what used to happen is, when there were collisions between two ships, there used to be an issue of collision liability. Traditionally, that was not covered under the hull policy. The owners went to the hull insurers and said, listen, we want cover for the liability arising out of a collision. And that's when they started having this 3x4 RDC in a hull policy, which means that only 3x4 of the collision liabilities is covered under a hull policy. There is a gap of 1/4. The reason why the hull insurers wanted the owners to handle it is because they felt that the risk will be much better managed if they retain that risk. That 1/4 is itself quite significant, and therefore the owners found a way to try and put it into a club. A club is not an insurance company, it is an association. And also the question of when you have a collision, when you have a collision, these are all the protection risks, so to say. Subsequently, there were issues for cargo liabilities in the sense that the cargo is loaded on deck or it has not been delivered in proper way. So there was exposure on that. Then you started having an indemnity club. Both these clubs at a certain stage merged and they became protection and indemnity. The majority, I think 95% of the world fleet of ships is covered on IG, international group of P&I clubs. And, there are 13 of them. About 5% is insured with a non-IG or on a fixed premium basis. What is good or bad is left to the user. I would not say one size fits all. Although the dominant view perhaps may be that IG clubs are the best fit, I don't subscribe to the view. I subscribe, you need to understand what you require. And if you feel that IG is a good fit for you, then you should take it. And if a fixed premium club is a good fit, then you may take it. The main difference is an IG club is an association. It is not strictly an insurance company, whereas a commercial insurer, a fixed premium insurer, is an insurer. He charges a premium at the beginning of the term of the insurance, event or the period, and he does not charge you, further calls, so to say, which you have in the IG system, so to say. Uh, so if you look at this cover is mainly given for liability. That means you have to have some sort of responsibility in law. It is not a property-based cover. So the first question you have to ask is, how should you deal with claims? I'm not such a big fan of cricket, although I hail from India. But I've used these two cricketing terms, front foot and back foot. If you actually play in the front foot, which simply means that you're going aggressively, you're going in to hit the ball. What it does is the bowler has to deal with your offense. You actually, the person on front foot is actually controlling. Yes, the ball is dealt to try and ensure it is done. So in front foot, you actually control. You are there in the heat of the moment. You are there, involved in it. The other way is you let the ball come, and it is a back foot. The bowler is the decider in the sense he puts the ball and you decide how to handle it. So that is what I would probably use as an analogy to say which is the right way. Different parties have different styles of dealing with it, but my view is that generally, in P&I claims, liability claims, it is always better to be on the front foot. The reason why front foot is better is you can actually deal with the issue, you can control that issue. If you are waiting for the event, let the event be sorted out and let me deal with the claim, you might at that stage, that is, if you're in the back foot system, you might at that stage find that, listen, I could have dealt with the claim much better, but because you're not there, you lost an opportunity, you would have to pay a higher claim. So invariably, if you look at liability claims, at least in the maritime sector, you would generally find that they are being dealt basically in the front foot. As soon as a claim is reported to someone, you will generally have an expert involved. Yes. And that expert will start dealing with it, assisting parties, probably on a without prejudice basis, because the liability aspects are yet to be determined. Sometimes the insurer might find that the event is not covered, or the insured, it does not have an entry, in which case what happens is there are some costs which are incurred, but at least they're able to stand down at that point of time. The advantage on back foot is you actually are able to ascertain all the incident, everything is there, and then deal with it, but you might have a bigger claim. Which is better? I have no answers to that, but going from what I know, if you are involved from the beginning, you can mitigate, minimize the exposure, and the costs which have been incurred, the burning costs, perhaps, the what do you say, the front rolling of costs, which is there involved at the beginning, so to say, is well worth it, because the actual quantum of claim is a much reduced figure. Uh, so who gives these assistance? Obviously, when an insured or vessel owner has an issue, he'd probably go to his insurer's P&I club. The 13 IG P&I clubs are not all over the world. They are seated in different jurisdictions like the UK, some Scandinavian countries, America, Japan. So they do have offices in different parts of the world, but it is not possible to have offices in more than 155 odd countries or 160 or 70 countries. So what they will do is perhaps look at third parties who are generally known as correspondents. So if you go to an IG club, you will generally have a rule book which will list a correspondent. And if an owner or a master has an issue, he is asked to actually immediately contact the correspondent, report the claim. When you have a claim, the master is under tremendous pressure. Everyone is hitting at him, although he might not be at fault at all. Yes, that is basically when you have a problem, someone tries to put the blame on someone else and walk out. So if he's able to reach someone who can hold his hands, who has got a local contact, who's got local context, who has got local, knowledge, then he can do the firefighting, assist the master, handhold him, and that's what is the way a correspondent will do. So if you look at the fixed premium clubs, they'll also name the correspondents in their policy, or you could go to their website, and the website does list out the correspondents, and they could probably attend, get their correspondents to contact their correspondents and ask them to deal with the issue. What about other covers? We've only been talking of P&I, which is the owner's cover. There are other participants in the industry, in the maritime industry. It's the owners also have a hull. So sometimes you have a collision, or if you have a grounding, the insurers might require assistance. They might engage an adjuster, and then adjuster might not be having his own office. So they would probably use a correspondent. You've got other transport intermediaries like charterers. If you really look at shipping, the owners used to operate ships by themselves, but now it has become specialized. The owners are now, most of the owners are in the process or in the business of owning ships. They charter the vessel to time charterers who operate the vessel, and the time charter might also sell it on voyage charter to someone else. So there are a lot of intermediaries which are involved. So each of them have a liability exposure. And obviously, if you have a liability exposure, you need to deal with the liability exposure. You talk about freight forwarders in NVOCCs. This is more in the container context. A freight forwarder assists clients. An NVOCC doesn't have, he doesn't own a vessel or doesn't operate a vessel, right? But he owns his own container, container fleet, and he could probably issue his own bills of lading. So you have these people who are also participating. What about other marine service providers? You have to admit that at the present situation, the world has become very litigious. If you have an issue, what you would generally find is people will shoot with a shotgun instead of a rifle. The difference between a shotgun and a rifle is a rifle shoots straight, so a bullet can only kill one person. Whereas a shotgun shoots number of pellets, a multitude of pellets, which tries to go in a parabola, trying to find someone which the pellet can sink to and try to recover on. The same way, if you have an issue and let's say the cargo is released without a BL, a cargo claimant would perhaps go after the owners, he would go after agents, he would go after multiple parties in the writ to see if any of them would actually be held responsible so that he can recover something. So therefore, marine service providers also have an exposure. Marine service providers can be agents, ship agents, yes. They can be surveyors, they can be any broker, a marine broker. So anyone providing this thing can also be, and then as they provide services in different parts of the world, and the insurance might be placed at different locations and might not be having an office, you might require a correspondent to assist in dealing with the claim. The question you have to ask is, who are agents? Who are correspondents? Are they agents? Well, they're similar to agents. They don't have a binding sort of contract that they will be used for each and every matter. But if they are used, then they have common requirements that they need to do their job professionally. They are generally vetted, scrutinized. So in the event, if there is a matter, you don't need to really go and check whether this is the right person or not. Correspondent does not know who is going to actually give him work. So the general rule or the commercial rule which everyone does is they generally take the first person who approaches them. And if the second person, a second insurer approaches them, they will probably say, I am conflicted. And then the insurer will probably look at other correspondent. In most of the locations, there are multiple correspondents. It is generally not an issue. But in some locations, it is very difficult to find a resource person or a correspondent. And you might find that there's only one correspondent location, and the correspondent then can go to both his principals, says if there is no conflict, or I use a China wall, I use separate experts, I will not pass. So if this type of China wall or different parties are there, it is quite possible that the same correspondent is dealing with multiple principals. It has to be careful. If there is a conflict, a good correspondent would stand on at least for the second principle. So it is, I have done it on that way. So it's quite possible sometimes, if you have multiple principals, the goal is the same, it's quite possible to work together. What happens if you're conflicted? The correspondent, the multiple correspondent, he could probably say, I'm conflicted, you can look for someone else. If not, if there is this unique situation, there is only one person, then, it's quite possible to work through, provided both principals are agreeable to it. If they're not agreeable, then I think the correspondent needs to, because the first one, this is principal, he becomes an agent at thing, he needs to do with it. What does a correspondent do? He's basically the eyes and ears of the insurer. He doesn't have his own authority, it's a delegated authority. If the insurer or the P&I club or whoever is insuring is comfortable with the correspondent's knowledge, then he could delegate authority. Otherwise, what would happen is they would make, they will review the matter, they will engage experts, surveyors to try to find out what exactly has happened, engage consultants, and then, report back to the insurer and seek instructions. Most of the correspondents are commercial men. When you have a problem, it is, very easy to get into looking at who's at fault, but not finding a solution. Ship owners only make money when the ship is afloat, when the ship is steaming. They don't make money when the ship is arrested or in a port when you're talking about it. So you need to be commercially sensitive, try to find, listen, we'll talk about the right and wrong, or even if there is, you're not wrong, let's find a solution which best suits your interest. So you try to look at issues commercially, in a sensible manner to try and find solution. Sometimes people are not willing to see reason. Then obviously, you allow the law to take its place, in which case most of the insurers are able to give some sort of a security. If you look at the IG clubs, they give something known as a letter of undertaking. If you go to the fixed premium club, they would be able to give us some sort of a LOU through a bank or other ways. And then when the ship is allowed to sail, then you can deal with that issue. Sometimes you have, in some rule books, you have legal correspondents. Basically, they are, engaged for the legal expertise in that country or the location. They represent the member or the insured in the courts. If there's an arrest, you would require to engage someone. If there's an arbitration in that jurisdiction, you would like to, engage them. So there are legal correspondents, and to deal with it. I understand it's a bit of a dwindling trade now because most of the P&I insurers, have engaged lawyers to deal with claims. So most of the time they try to deal with it themselves. But in the past, I believe there was much more work to the legal correspondents. So if you need to go to court, you need to engage local lawyers. So that is, different countries have their own rules as far as Legal Profession Act is concerned. So then obviously you need to engage a lawyer. So if you already have vetted the lawyer who knows about this business of shipping, it's much more easier to deal with it. I thought I'd touch about, two incidents in my life, what made me get into this, what I could perhaps do it, and why I enjoy this. When I was a youngster, I joined a company known as C Asia P&I Services. It's still running, it's pretty active. It has offices in different parts of Asia. And when I was, in the initial first year of my service there, I was involved in a collision between two vessels, Sanko Robust and Tirtha Mas. We were actually engaged by the P&I insurers of Tirtha Mas. There's a collision in Malacca Straits. It's the straits, which waters are joining Indonesia, Singapore, and Malaysia. And the vessel Tirtha Mas sank. Following this, obviously, people start looking at the best way to deal with it because, what happens is when you have a collision, each party is liable. There is an apportionment of liability. And then you have to understand that there is an issue of limitation of liability. There are two main conventions. One is the Ship Owners Limitation of Liability 1957 Convention, which has a lower limit, but the limitation can be more easily broken. At that point of time, both Singapore and Malaysia were signatories to the 1957 Convention. There are also other countries which had signed the 1976 Convention, which has much higher limits. But the giveaway rates, it is very difficult for to break the entitlement of owners limitation. That means it's very difficult to break it. Sanko Roberts obviously wanted to try and found jurisdiction insofar as Tirtha Mas is concerned in Malaysia or Singapore. But they tried their best. They found the anchor of Tirtha Mas. They issued a writ and tried to serve it on it. The anchor is not the vessel. Yes, so there was a lot of as you go through it, this is a good point of acting as a correspondent. There's a good point of in being involved in disputes. Every issue is different. You need to look at it is unique. You need to try and find. I was actually, a few months back, I had done a research for a paper which my colleague, my boss at that point of time, some of you may have heard of his name, Robert Gordon, was going to speak in one of the conferences, and that was on the limitation of liability, 1957 and 1976. My research indicated that India was actually a signatory to the 1976 convention. When I checked with Indian lawyers, they themselves are not aware. I'm sorry to say this, because even if a country signs a convention, in order to make it law, there are some other procedural requirements. It needs to pass through the parliament. It needs the assent of both houses of the parliament. It needs to be signed by the president. And then, it needs to be published in the Gazette. Yes. So we knew for a fact that India had signed. I was in Singapore there. And, and when you talk with Indian lawyers, they were not sure.
Sir, sorry to interrupt, just to make an addition, we have the merchant shipping rules on limit of liability on maritime claims in India of 2015. So they have actually implemented the 1976.
It was much before 2015 that, I'm talking of before the 2015 MSA came. 1976, India signed, but it was, there was a bit of gray because it was perhaps not published. Fortunately, because I reached out to my contacts, I did get from one of my contacts in India that he has a copy of the Gazette. And when you got the copy of the Gazette, the owners, insurers arrested the vessel at Cochin. The opponent insurers did not know what happened because India is a very difficult jurisdiction because you need to pay money to they don't actually accept LOU. If the other party doesn't accept, you need to pay the money to the court in Indian rupees. So it is not the best of jurisdictions. It might not be good for one, it is good for the other. It's actually a tactical measure. But when they realized the game was actually on the 1976, then what happened is both the insurers agreed to settle at a higher amount. The difference was about 4 million. Yes. So what you need to do if you're involved as a correspondent is to try and use tactical measures, persevere, don't give up, have the right contacts. I did a lot of things. I got, because the vessel was going to be arrested in India, I got it signed, the owners of Tirtha Mas were in Indonesia. So they had to actually give that power of authority or attorney for the writ to be issued. And it has to be, legalized in the, Indian embassy in Indonesia. I got that signed on a Sunday. So I just picked up the phone, talked to the, council, the foreign officer council there. I said, can you do it? It is important. And I think, if you don't try, you don't know. And I, even the Indonesian counterparts who got it signed, got stunned that people are willing to do it. There's nothing wrong. You need to keep on trying and you can find a solution. So that was one which I was involved. And then I realized that, you need to, there's no right solution or wrong solution. You can always find a solution which best fits it. And I probably take the next one. I was involved basically for a container operator. There was this Herbilian who were actually running feeders. It's very easy to get into the shipping industry. You probably charter vessels and start doing service. And sometimes what happens is you really do not do your mathematics properly. And then if this is what happened. They were trying to sell aggressively, not realizing that, at some point of time, it's going to bite you, and it bit them. So the charters went bust. So the persons who engaged me were for container operators. They had about 150 odd boxes on board this vessel with cargo. The exposure was huge. They had more than 15, 20 million worth of cargo in this vessel. So I wrote to the owners, listen, I have an interest in this vessel. Please let me know what your plan is. Obviously, if you try to not perform the voyage, I will arrest the vessel and I'll do what is necessary. The owners' insurers knew me in the sense in my previous avatar when I was working in Sea Asia, I had done some work. So they approached me whether I could work in a joint capacity. So then I did go to my first, principal, so to say. I said, do you have any objections? Because obviously you need to find a solution. I would obviously not want to be conflicted. If I'm conflicted, I will stand down. But they agreed because obviously they wanted a commercial solution to get the container to the destination port. The advantage of me is I've been in a commercial role, so I know how shipping works. So I was able to look at to find the gaps, so to say. I told all the cargo interest, the container operators, that listen, owners want have a lien on the outstanding freight. If you are paid the freight, please provide evidence, because if you look in the container industry, bills of lading is generally issued by the container operator as freight as agreed or freight paid, but it does not necessarily mean that the freight has been paid. So, because if you have a freight prepaid, owners do not have a lien on the freight if it has been paid. So on that aspect, I said, if you have paid, please provide evidence. Otherwise, we are going to hold lien on the cargo, because this is an entitlement under the bills of lading, which has been issued by the operator. So what happened is parties realized they were happy to settle. We used the monies to actually fulfill this voyage, to pay for the the discharge costs, because in this location it was on CY basis, and the CY basis the cost was tremendous. So anyway, so what happened is the moral of the story is, although owners lost a lot of money because they did not get the outstanding hire, when they decided that the voyage, the charter parties terminated, they could actually fulfill their obligations, discharge the container. They didn't lose out of the last voyage, and they moved on. So that in effect is what I did. I thought I'd share these two. I think I'm done with that, except that what does a correspondent do? He plays a very important role. He looks at finding a solution, more often a commercial settlement, commercial solution than a legal solution. He should know about the legal entitlements, because without knowing it, you will not have a basis. You should know the trade, and a correspondent should know the trade. If he doesn't know the trade, he should know someone who knows the trade. Yes, it is very important to know someone who can do it, and he's basically a Mr. or Miss Fix It. Yes, so someone who can fix the problem, try to find a solution. I think that's all for me. Thank you very much for inviting me. I'm happy to take questions, and the floor is yours now.
So thank you for this wonderful information, which have been very informative. I personally have learned a lot from the presentation that you've given. Thank you so much. So now I'll ask the audience that please ask whatever Q&As that you would like to, whatever questions you would like to ask. I invite all the participants to please whatever questions are coming in their minds, please address. They can write in the chat box, or they can ask me to unmute them. I'll be more than happy to do that, so that we can have a deliberation. So, sir, until I receive any question, there is one question that is coming up in my mind, if I may. So, sir, in these majorly under the bunker convention, there is a provision that that in case there is a spillage, so the shipping company, the ship owner or the insurer has the responsibility to pay compensation whatever they can initially. So in that, the situation may occur that sometimes when bunker insurance come, the people, the insurer, they might not get insurance from the IG groups. They might go to a non-IG group, and the amount of insurance that they purchase might not be adequate enough. They will purchase the adequate amount of insurance, but the insurance company in itself might not be competent enough to pay the massive amount of compensation that are often claimed in the environmental issues. So what is the solution at that end when the company, when the insurer has itself stated that it is not in a position to pay the required amount of assured compensation.
I think what happens is before a vessel enters into a port, it is important for the vessel or the owners or the agent to provide evidence that they have financial responsibility by way of insurance. Some of the countries, what they do is they vet, and it is also the insurer wants business, he gets himself in the included risk. In some countries, they say they only accept IG group because they have a good reputation. But in some of the other areas, some insurers who say, listen, I want to be in the business, they ensure to get also included in the list. So if, for the bunker convention, because the bunker convention is on strict liability, you don't need to have evidence of fault.
Right.
If you're not able to provide that cover at that point of time, then the paper is of no use. So when a charterer or someone is doing business with someone, he probably will ask, the name of his insurer, and he could probably check whether that vessel is entitled to come to us on that paper, so to say. So I think everyone has a due diligence thing to do. And if the charterer or a person who's using a vessel knows that there might be issues, he could probably tell them, listen, you have an issue, can you confirm you'll be able to handle, or don't get into this place? I think people are finding a way, to get around it. But yes, in answer to your specific question, IG group P&I clubs are generally liked because they generally deal with it more effectively. If someone goes to a third-party insurer who is not doing it, I'm sad to say that insurers, it gets a bad name to the fixed insurer, but that does not mean others are not able to deal with it. So it's just that there's one thing, but bad news sells. So that's why the fixed premium insurers might get a big name. But also the other participants in the trade have a duty to check who their counterparty is. Is he properly insured? I hope that answers your question.
Certainly does, sir. Because in this bunker, it's not like they're having a supplementary fund or fund. There is a assembly that is sitting similar to how it works in the fund commission. So in the bunker, if they are not able to pay, it brings out a major problem. So yeah. Yes, sir. So, now I have another one question from the participant. Mr. Siddharth, he asked that how much time insurance company takes for settlement on a vessel collision when the owner of the vessel declares journal average. This is in respect of charterer's perspective in a voyage charter, your experience in handling such kind of situations.
Okay, there are two things. If you look at collision, it is basically collision liability. 3/4 is generally insured with the property insurer, hull insurer. 1/4 is actually insured by the liability insurer, because the hull insurers traditionally say they don't want to insure that. They wanted owners to deal with it. It is now possible to get 4/4 either from a liability insurer or from a hull insurer. So generally what happens, since it's a liability has to be determined. It might take time, it might be done fast. Because it is from parties who don't have a contract, it will generally be by founding a jurisdiction, by arresting a vessel, or by agreement, which can be by exchange of LOUs, and it can be by agreement of using a jurisdiction of a specific court, or by arbitration. Like in Singapore, CMA, they have an expedited collision process which parties can voluntarily choose. So to answer to that, collision is concerned, it all depends. Some courts are fast, some courts are very slow. If you had a collision in India, you'd probably have to ask, how soon can the Indian courts deal with it? So that is the answer to that specific thing. Some jurisdictions are pretty fast. Singapore is pretty fast. If it's a matter which is held in Singapore, Malaysia is also pretty fast, and the UK is very fast. So it all depends. Insofar as general average is concerned, general average is not dealing with a collision per se. If you look at the definition of general average, if it generally is it's incorporated into the contract of affreightment, be it the charter party or the bills of lading, and it would be on the basis of Rule A, which basically says any extraordinary expenditure or sacrifice incurred in a moment of danger for the benefit of all parties should be shared. So the collision-related expenses will not be shared, but after the collision, if you have to do emergency repairs to the ship so that the voyage can be accomplished, that would fall on GA. If there is a fire and to put out the fire, you had used water or expenditure, and you'd also spoiled some of that would be covered. So invariably you would find that, general average would be adjusted faster. If it is a bulk vessel, I don't think a GA should take more than a year or 1.5 years. If it's a container vessel, yes, technology is there, but the problem is in a container vessel, it's become very complex. Uh, the other problem is most of the cargo interests are uninsured. So, half of them don't know what they are doing, unfortunately. So it is a few years. When I say a few years, I've seen a GA adjustment also coming after 9, 10 years, which is bad for the industry. I think, the optimum within a year or two, if the adjusters can submit the report. And this is also contingent on all the information being provided by all the participants, because the owner might be able to provide the information, the others might not be able to do. Now, the question was asked specifically for voyage charter. What is the interest of a voyage charter insofar as a collision is concerned? The vessel is not his. The cargo, if perhaps he's a cargo owner. So in a GA, he is interested because he will be contributing. He might be interested in the GA if he's in the collision, if he's a cargo owner, perhaps to recover on the basis of apportionment of liability. Generally, what would happen is he would allow the P&I club to try and find out the apportionment of liability. He would participate. Otherwise, he'll have to put money, engage his own lawyers. And once the apportionment of liability is there, then he would ask for his portion of the portion fault of the other party to try and recover. If the cargo interest is insured, that is something his cargo insurer does it because it's on the rights of subrogation. So the moral of the story is, if a voyage charter, it would be best if the cargo is his to ensure he has got cargo insurance, and there is exposure, is issues of these both of collision and of GA is limited. He doesn't have much exposure. I hope that answers your question. I see a question on general average. If it's okay, I'll take it so that I can probably, general average looks nice nowadays because you have a lot of general average floating around. An average adjuster's, opinion is only an opinion. If a party is not happy, then obviously he could dispute it. Yes, you would need to probably look at whether in your whether you have what do you say changed the agreement, the contract. Generally what happens is all contract of affreightments or bills of lading have a jurisdiction clause, a dispute resolution and jurisdiction clause. In the latest ever given, if you go to my website and read an article, I did mention that when they ask for security from cargo interest from average bond, they asked for trying to change it to arbitration under LMA rules with English law. So basically, you could vary it after the event. There's nothing against varying it. So if you have varied it, you would need to look at the varying, what you have varied, and then you have to, if you are not happy, you would need to use whatever has been put in the clause, so to say. I think that if there is arbitration, yes, like the latest one, there is arbitration. So if there is an issue, you can say I do not believe you are correct, so I would like to arbitrate. There is a procedure, the LMA procedure, and you need to call the owners and then engage an arbitrator, engage your own counsel or a party appointed representative, and allow the arbitration to proceed. If there is a court jurisdiction, then you need to go to the court and say this party has agreed for this jurisdiction, and let the court deal with that issue.
All right. So there is another question from Miss Shristika. So I think she wants to ask, so could you explain how does a legal department work for cargo claim issues in a shipping company, and any advice for the same?
Okay, the major claims, if you really look at it, is by volume is cargo. If you look at a ship owner's office or a P&I insurer, I would believe the major volume would be cargo claims. But if you look at value, I think it would be the other third-party claims or other claims like pollution claims, which will be much more, collision, which will be much higher. So once you have a cargo claim, what you would probably do is you would probably engage the club or the ship owner's legal department. Will try to ascertain the circumstances of the loss. They'd probably engage a surveyor. if the incident is developing, to actually take pictures, to be present, and also assist on a without prejudice basis. Assistance should not be construed that there is an admission of liability. Many a times, I'll give you a small example. Let's say your cargo is very damaged. Obviously, the cargo interest will say the cargo has got no value. If the surveyor is good, he will say, yes, you say it has got no value. Why don't we put it in a salvage sale? It will then find out what the value is. And the surveyor, if he is good, he'll be having his own contacts. He'll invite somebody. So you're able to do a mitigation of risk or mitigation of loss, so to say. The claim which could have been 100,000 would now be reduced to about 20 or 30,000 if you have followed the right way. And if the cargo interests don't do it, the survey will put in his report, I have submitted, I have asked them to do it. He gives a written note that I would recommend that you do it. And he has got evidence, so which will also be of assistance when you want to deal with the claim. Once you are doing this, there are two issues always in every claim. One is the quantum, one is the liability. Here we are talking of quantum when you've got a surveyor involved. Then the question of liability is concerned. Are you liable? Is there a fault? Again, a surveyor's report will assist whether the cargo has been lashed properly, loaded properly. Was there something which could have happened due to inherent vice? So these things will be touched on by the shipping company's legal department, and they will try to deny. The general view everyone does, is that, when there is a cargo claim, you would probably find a shipping company saying that your loss is being investigated, and they would keep quiet for 365 days. And on the 366th day, if there is no further correspondence or any legal writ, they would say your claim is time barred. This is the reality. Everyone plays a tactical game. Even I will do it if I'm engaged by a ship owner or a person dealing with cargo claims, which is perfectly okay. So people who are cargo interests should know the drill, so to say. They should not get seduced. I'm sorry if I'm using a bad adjective. They should probably know that, listen, if you have a good claim, you should initiate action so that the other party knows that, listen, you're serious. When the other party knows you're serious, then you can talk about commercial negotiation. I think at that point of time, parties will try to negotiate, looking at what is the cost of pursuit, what is the cost of defense, what is the what are the chances of winning. Yes, many a times parties think he's going to get everything. Reality is something else. If you're going to be dealing in a jurisdiction like India, it might take 10 years. So you probably say, I pay you the money now, but you're going to get it after 10 years. You need to give me some sort of a discount. So you need to be a bit more commercially minded. It might look a bit obtuse, but that's the way reality is. You need to find a solution and everyone is happy. That's what a shipping departments or anyone who's dealing with cargo claims is concerned.
Yes, totally agree with you. So these kind of things. Also, sir, I've seen that, and if you see Hague-Visby rules, it provides a defense that in case of fire or peril at sea, the compensation will not be provided. The ship owner, insurers are not liable. But it is very difficult to prove, in fact, that the fire has happened because of the fault of the carrier or not, because the evidence will be burned along with the whatever has happened.
I agree, but it's basically an allocation of risk. So
Right.
if the cargo is being insured, the cargo insurer would pay.
Yeah.
Let the both insurers fight.
Hmm.
The problem comes when people try to save 25 or 50. Cargo insurance, incidentally, is not very expensive.
Right.
Insurance is something which it is, you hope that you don't have an incident, because if you have an incident, you're not going to be paid for all your losses. But if you have an incident, if you don't have it, you're going to feel a very significant exposure. So my recommendation is, even if you had no loss for the last 20 years, please consider, because this will actually allow you to be a bit more, sleep more properly if there is a loss.
Certainly. Sir, I have another question by Mr. Gupta. He wants to know about the role of PNI correspondence in claims related to maritime labor laws.
Okay, I must confess, that I don't deal so much with owners PNI except for the FD&D. But if you look at a vessel owner, he is actually the employer. He has got an employer-employee relationship with the crew. So if a seafarer dies or if he's injured, then the owners have a liability on that. So there is a convention which different countries have signed, which have set the basic ones, what is there. So if you have these conventions, if your country is a party to it, then obviously the insurer will have to honor it. So the P&I clubs which give these blue cards or whichever cards which are there will obviously have to deal with it. And if there is a claim, and then the P&I correspondent will try to facilitate, will look at what is the amount which has to be paid under their laws, because what will happen is if you're signing a crew from India, then Indian law applies, and then you look at the contract and try to deal with it. I hope that answers Mr. Gupta's question.
So the next question is by Mr. Elish Anthony, but I think you have already answered this question. I'm not sure. It's on journal average and bill of lading, sir. When there is a clause on the journal average in bill of lading, whether the cargo owner can disagree with the settlement amount suggested by the journal average adjuster. If in that case, what is the remedy available to the cargo owner? Do they need to approach?
I have actually dealt with it. It all depends what is provided in your contract.
Yes.
If your contract provides for an arbitration clause, then you need to arbitrate.
Yeah.
If it provides for a specific court and jurisdiction process, you need to deal with it.
Yes. So the next question is again by Mr. Siddharth. He wants to know that in case so vessel collision in anchorage, will it be considered within the port area?
I think the issue is you need to look at the jurisdiction. I was involved in an arbitration wherein someone said it's outer anchorage and anchorage. In some countries there is no outer anchorage; it's only anchorage. So anything outside anchorage, if it's outside outer anchorage, does it fall within the port limits? That's what you need to look at it. So you need to go and look at what is the rules or the law in that area to find. You cannot have a one size fits all. So, if it is irrespective in anchorage or outside anchorage, it would be within the, definition of an area. It would be under the the area of some country wherein those laws would apply. So, but the question is, if it is outside, you probably have to found jurisdiction because the vessel will no longer be there. But yes, I don't have any answers because port area, you need to be specific. Is it in normal anchorage? Then yes, it is in within port areas. But if you say outer anchorage in some ports, there is no definition of it. You just say anything outside the port is outer anchorage.
Sorry. Right. Thank you for your reply, sir, to the question. There is another question from Mr. Mohsin Ali Beg. So he asked that this is a claim notice period which consignee can serve to this shipping company for damage to the cargo, and ultimately this will be handled later on by the insurer against the letter of subrogation. If notice not served on time, can the insurer still pursue their claim against the shipping company?
I think the answer to it is basically if the notice has been given properly, it fulfills the notice requirements under the Hague rules or Hague-Bisbee rules. So what happens is the burden of proof shifts to the carrier to prove that the loss happened without their fault. If the notice has not been given within the initial period, there is nothing preventing the cargo interest or the subrogated insurer. The subrogated insurer, insofar as common law countries is concerned, he is not pursuing in his own name, he is pursuing in the name of the insured, which is the cargo interest. But the burden of proof shifts to the cargo interest to say that the loss was due to the fault of the carrier. That's a major difference. I think tactically, I would probably put a notice saying that, if there is a loss, I invite you for survey. So everyone is there. So you cannot say I've not been invited. But not providing a notice on time within the 3 or 7 days, depending on which convention you're involved, is not a bar for pursuing later, but the burden of proof shifts to the cargo interest. I hope that answers Mr. Baik's question.
So there is another request by Mr. GVN Rao. He wants to know if you can share a brief about your journey and about your field.
Mr. Rao, I think there are much better people who have much better experience. I am someone I'm still in the journey. I am running a very small, a boutique firm, trying to deal with it in a very proactive way. But if you look at, I come from India. Actually, I was born in Orissa. I'm a Tamilian by mother tongue. I probably speak better Hindi than Tamil. My father was in the railway, so I travel the length and breadth of India. Probably I'll tell that later why we travel, but it allowed me exposure to different cultures, different languages, different people. I started my shipping career at Cochin, which I don't speak Malayalam, and I came from Tamil Nadu. I went to Kerala, and it's a different language. I didn't know the local language, but what happens is it's a never say die. You to try and gel, try to find a solution. I stayed there. I got an opportunity to study in Rotterdam. I did a course in port shipping and transport management, and that's how I tried to focus more into shipping. Then I came back to India, and I felt that it was time to move on, and that's how I moved to Singapore. When you do some courses, you think you know everything. I still don't know anything, but the question is, when you're young, you are under the premise, listen, I know everything. And I was in that haze, so to say. I was trying to find a way where I could share my thoughts. I was involved in one of the training institutes teaching on marine insurance, and when I came to Singapore, that is when someone saw me and said, "You talk about this. Would you like to be involved in claims from the other side?" And that's how I joined a P&I correspondent company in Singapore. Generally, P&I correspondents generally come from legal background or come from a background with law and insurance, not from the commercial side. I came from the commercial side. It was much easier for me to find solutions because I was trying to find out what is it you want and how do you deal with it? How do how can I, this? So I enjoyed it a lot. And that's how, I said, okay, let me learn more about it. I did my degree in law. I am still studying. I'm still doing things. Every day is a learning experience because that's the way it is. So I'm running now. Now is basically a boutique firm which looks at assisting parties who want to engage us. I hope that answers your question, Mr. Rao.
So there is one last request actually that has been made by Mr. Nano. So he would like to ask his question himself. So with your permission, I will unmute.
Please.
Please, Mr. Nano, I've given you the access. Please go ahead and ask your question.
Hi, morning, sir. Morning, everybody. Okay. Jagan, sir, this is my great pleasure and what saying that chance to attend your second class. I have got the chance to attend one of your class at Dubai while you are conducting a class with the ICS Institute of Chartership Brokers.
Yes,
Okay.
yes,
Okay.
Please go ahead. Okay.
Okay. The question is that, okay, in a shipping industry that end user players like the land transport company who are moving the container and non-containerized cargo, warehouses, logistics, and freight forwarding companies, and these type of that, the smart players, they are not that much of directly involved for the totality of that, this one, even though how each of them will get the services of that, the P&A club. While, for example, a transport company, if they're moving a year, 1 million TEUs or what it is called a non-containerized cargo, how they will get the insurance coverage on there. If they have that the problem, how they can reach to P&A club, including that your arbitration fund, please.
Okay. Actually, to be very frank, that's a class of business I specialize. My background is I've started working in a shipping in an agency firm, and I've done container business for quite some time. So there is no P&I club. There are basically liability insurers. There is one mutual liability insurer known as TT Club, which has got about 80 to 90% of the market. There are other commercial insurers who are also providing service. I'm actually engaged by some Lloyd's syndicates on a use basis. Then as a correspondent, they will engage me when they feel that, okay, we want to engage an expert or a correspondent to deal with the claim. The problem comes in some jurisdictions, people, are not aware of their exposure. They don't have best practices. But in developed jurisdictions, let's say Singapore or, UK, it is a requirement that, you need to have. Even the counterparty will ask if there is a service level agreement that who's your insurer when there is a problem, they need to, I would like to know, so they have an issue. So I think if you want these issues to be solved, you need to look at insuring yourself with an insurer who has this cover, and who has a claims perspective. Like I talked about earlier, there are two styles of claims handling, front foot and back foot. This should also be done in the front foot, because if you do in the front foot, not only you're dealing with the claim proactively, but you also people know that you have the knowledge and resources to deal with such matters. Otherwise, there have been instances in which there's a lot of negative publicity following an incident, and even though they might not be the fault of the freight forwarder or the haulier, it might affect their business seriously. So I think, Mr. Nanu, I think there are insurers available. I do not know which jurisdiction you are doing business. They should be able to assist you. You should go and find a good broker. Unfortunately, I don't do broking. I'd like to be neutral. You should go to a good broker who should guide you to find you the right cover available to deal with these issues. I hope that answers your question.
Sir, that is absolutely correct. Why I'm asking that even if we consider that the UAE, while the hauliers insurance, while moving the container from that the Jebel Ali port to or that any destination of that the customers the warehouse, if there is any accident or damage or something is going on the wrong, the thing which I have that from my experience, I have also near around 25 years experience in the UAE. Right now, I am also entering to that the consultancy of this one. So I need your service also in a vast way. The problem is happening that while we are taking such type of the insurance issues, shipping companies and everybody is taking their hand. They are saying that you have to go to your insurance company. The insurance company also, they are only issuing that the whole year's insurance policy, but a professional the service or how to settle this issue is getting very difficult. That is why.
No, Mr. Nanu, I think what happens here are two issues. There is a cover, but the claims handling expertise is not there. I have handled claims in Dubai also. So perhaps there is an opportunity for people like me or people like you who want to be involved to provide this service. So the question is, someone has to pay. If people don't pay, then people like me will not be involved. So the industry feels there is a need, they will find a solution to it. But I must confess, I have dealt with claims in Dubai, haulier companies. One of the common issues I've seen is generally people find a haulier who's cheapest, is from the neighboring countries. The driver runs away, and it's a one man show. And generally, there is a bit of chaos after that.
I don't know. I'm taking myself. This is happening that because of that. Sometimes the negligence from the shipping company also, because the shipping company is not giving that the clear picture. Okay, a transport company must have to need that whole year's insurance and the stability on like this. Instead of that, they themselves is forgetting that the cheap rate. They themselves is promoting that the single vehicle owners. You know better than me on there, because in many cases it's happening on like this. Anyway. Okay.
I have a different view. The shipping company's role ceases after discharge. If he is acting for doing the transportation, then he would be acting as an agent of the cargo interest. So then the question is, the cargo interest can actually choose a better interest, or perhaps if he's not able to do it. I think there is more to it. I think you are based in Dubai. I would probably recommend that you talk to. I think Dubai Freight Forwarders Association is there. I think you probably have to find a solution locally. And yes, there is liability insurance available. There is given locally and also internationally, which can deal with these issues.
Thank you, sir. Thank you very much. Anyway, I would like to reach you, okay, in very soon. Thank you very much.
Most welcome.
Thank you, sir, for taking this deliberation with Mr. Nano. I believe this resolved these issues. So there is one last question, with your permission, if I may ask. Mr. Ashley Anthony have asked this question. He wants to know, sir, if the cargo lost overboard during the voyage, what all the things are to be considered in a cargo entries point of view?
Okay, I think the first thing you have to do is your cargo insured or not? If your cargo is insured, you must notify your cargo insurer immediately and allow the cargo insurer to engage his correspondent expert to deal with the claim. Okay, because he or she, the company, cargo insurance company, would be having the assets in place, contacts in place to deal with it. The second question is whether it falls in one of the exclusions provided in the Hague or Hague-Visby rules. Whether it is a perils of the sea. Yes, perils of the sea is an exclusion under the contract of carriage, as per the Hague-Visby rules. But if you can prove that the cargo was not properly secured by the owners, it could perhaps be argued that it is actually failure of Article 3.1 and 3.2. So all these things will only come to know when you have a proper investigation. Yes, to know who's at fault. Don't take it at face value. Who's at fault? Even if the owners were liable, they are at fault. They can still limit liability, which is provided under Hague-Visby rules 2 SGR per kg or 666.67 SGR per package, and which might not be enough. So my point is, one, make sure you have cargo insurance. If you have cargo insurance, have a responsive cargo insurer. I will not say who's a good or bad insurer. The proof of the pudding is in the eating. When there is a claim, how does your insurer deal with the claim? It is not the premium which should be the sole decision maker for a person. It should be how is the process dealt with. And you probably find that you might get better service for a decent increase in premium, and which you may wish to consider. Again, this is something which you should choose. Talk to your broker, who probably guide you. I hope, Mr. Anthony, I've answered your question.
Thank you so much, sir. There have been quite a lot of deliberation today, I believe. So I think these are all the questions that I have, sir, for you. So I would once again, I would like to thank you for coming up, accepting my invitation, and to give this wonderful session. So actually, I just saw two more questions, if you're fine with it.
Please.
Okay. So there is one question by Shrika. So what are the steps to be taken by a young advocate to get the expertise and position oneself in this particular domain? And what can you please share your experience and insight on this?
Okay, I studied law as a second degree. It's not my first degree. I am not a lawyer. But if you want to be involved, what you need to do is get your feet wet. Go and work from one of the firms which are involved. Go and work with the freight forwarder, work with the NVOCC, work with the shipping agent, work with the P&I correspondent, work with the insurer. I think these are the people you need to go. When there is a claim, go and see it. Visualization is very important. And the analogy which I could probably get is, if you have a claim and someone says it was starboard, I'm sure that 90% or 80% will not know what is a port and a starboard. But if you're doing shipping claims, you need to do it. And that the advantage for a master mariner or someone who's sailed, it will come instinctively because he's visualizing. Starboard means, you see it is right. So the same way, if you want to get involved in maritime claims handling, you need to get your feet wet. You need to go to the place. You need to see the claims. So that's the worst way you to do it. And then afterwards, you could be at anything. You first get your legal knowledge, then you get your practical knowledge, or you get your practical knowledge and get your legal knowledge. So you could do anyway, and that should help you in your career growth. I also see there is a question on Ever Given, which I can't resist answering. There's a question answer to me. I don't know whether it's been there or not. I think Mr. Captain Alex Anthony has asked that. He's asked about GA justified or not as far as Ever Given is concerned. I think there is, GA is actually on the basis of equity. That means it should be fair and equitable. The very fact that the owners and the SCA have signed an agreement which is still shrouded in secrecy, I don't think that amount or whatever they are settled should come unless it is openly disseminated. When you talk about equity, it should be fair and thing. That is the main grouse about it. There would be some elements of the settlement which is to deal with GA related items. Some of it would be loss of revenue that is not related to GA. So you need to really understand the circumstances. With the limited information, I'd probably say there is an element of GA, but how much of it, I don't know. That 25% which they have sought, I don't think that is fair. But like I said, we need to wait and watch. These are my comments with limited knowledge. People with more knowledge will probably deal with it much better. I hope that answers your question, Captain Anthony.
So there is one last question, sir, that is in front of me. That can P&I clubs contribute towards decarbonization of the shipping industry?
P&I clubs are liability insurers. Why should they They're there to make money. They are mutuals. They say to be very frank, they all say they're not making money. But if they don't make money or they don't break even, they'll be out of business. They will not be having a rating. I don't think. What happens is, let's be fair. Shipping is a business. You pay for it, you get it. If you want decarbonized vessels, you pay more. Why do you want your insurer to pay?
Yeah, very right, sir. So these are all the questions, sir, that I have for you. So I believe that this has been an enlightening session, and I'm getting wonderful feedbacks also in the chat box. I think you can also read them. It's for you also, for you. Good. So thank you so much, sir, for giving this wonderful session. So I'll request the participants to provide their feedbacks in the chat box. Whatever suggestions they would like to give, they can please write ahead. And I most humbly thank you, sir, for accepting the invitation and giving this wonderful webinar on P&I clubs. So thank you. It's much better topic that you opted than what I have suggested earlier. Much
Thank
more
you. Thank you very much. Thank you for inviting me. I hope it was illuminating, and there was a conversation we could have. And I wish everyone all the best. I think it's time to log off, and we need to all make a living to earn our livelihood. Thank you very much. Have a
Thank
great
you.
day.
Thank you, sir.